everyone, and thank you so much for joining us today for our presentation on the L-1 intra-company transfer visa. My name is Dustin Saldarriaga, and I am a senior associate at Scott Legal PC. My colleague, Kelly LeGrand Weiner, will also be joining us today to present on the L-1 visa. Kelly is the managing partner of our firm and has extensive experience preparing L-1 visas, as well as a variety of other visa options. A few housekeeping items before we get started. This webinar is part of a series. We try to do, typically at this point, at least one webinar weekly, and those do cover the full spectrum of U.S. immigration. Our firm, even though we do have a focus on business immigration, we handle all types of U.S. visas, whether that be family-based green cards, temporary visas like the TN, the F1 student visa, the H-1B, as well as a variety of other options. So our webinars do cover that variety of visas. After this presentation, we'll send you a link where you can sign up for future webinars. We also do record our webinars. So this webinar is being recorded. We post our webinars on our YouTube channel, as well as, again, a variety of shorter videos on visa options. So we do hope that you'll check out our YouTube channel, as well as sign up for future webinars. If you have a question during this presentation, please do send it in using either the chat function on Zoom or the Q&A function on Zoom. And we will be monitoring those questions throughout the presentation. We'll probably save questions for the end, but feel free to send them in whenever they arise. So without further ado, let's go ahead and begin our discussion about the L-1 visa. As the name suggests, the L-1 visa is an intra-company visa. So what that means is that there is a company with a presence outside the US that wants to send an employee, a manager, an executive, someone with specialized skills or knowledge from the foreign country to the US. So that could be to the US to work for an existing business entity that's related to the foreign business, or to start a new office. So we'll talk about in more detail what the different roles are for the employee who's traveling to the US, as well as the requirements for the company. So the basic requirements for an L-1 visa are that, first of all, there needs to be a qualifying relationship between the company that is outside the US and the company that is inside the US. So there are a variety of ways that those two companies can be related. One is that there can be a parent relationship. So this is where one of those two entities owns the other entity and oversees it and has authority over it. They can also be affiliated. This is actually quite common, where the ownership is not identical, but is substantially the same. So by and large, you do have the same owners of the two businesses, even though they are not exactly identical. The businesses could also be a branch of one another. So the foreign business could be opening a branch in the United States, or a subsidiary. All of these are defined in the regulations, but the takeaway is there are a variety of relationships that the foreign entity and the US entity can have to satisfy this first requirement for an L-1 visa. Both companies, the company outside the US and the company inside the US, need to be doing business on an ongoing basis. So this means the regular, systematic, and continuous selling of goods or services. So it is not sufficient if one of the two businesses is dormant. If one of the businesses, for example, the foreign entity, has been sold, those are going to cause problems. So both of these businesses do need to be active, existent, and actually doing businesses. Now, there is a slight exception, which is when the foreign business is starting a new office in the US. So we will talk about what that means and how that is an exception to the US business be actively doing business at the time that the application is submitted. The third requirement is that the employee applicant, so this is the individual who's applying for the L-1 visa, needs to have worked for the foreign company for at least 1 year. And that is 1 year in the past 3 years. And they need to have done so in a managerial, executive, or a specialized knowledge position. We'll talk about what those terms mean in a following slide. So we will get into those details. Really quickly, though, there are two main subcategories of the L-1 visa. The first is the L-1A, which is where the employee applicant, so the person who's applying for the visa, their role in the United States will be managerial or executive. So they'll be acting as either a manager or an executive. Again, those terms are defined in the regulations. We'll talk about what they are in a couple slides. And the L-1A visa holder can renew their L-1A visa for up to 7 years. So there is a maximum limit on the number of years that someone can renew their L-1A visa. For the L-1B is for employees whose role in the United States will be one requiring specialized knowledge. And again, we'll talk about what that means. An L-1B visa can be renewed for up to 5 years. So again, there is a maximum limit. And for the L-1B, it is slightly shorter than the L-1A. I mentioned the new office. So the L-1 is interesting in that it can be used to start a new office in the United States. So a helpful example of this is if there is a company abroad and from abroad, they have started forming ties with customers in the United States and they decide, you know what, we actually want to start an office in the United States and we are going to send one of our executives, let's say from Colombia to the United States to actually start this new office. The US entity, the office, does not have to already have been operating as is the general requirement. So this is a nice exception for companies that want to start a branch in the United States. So there are some additional requirements, however, if you are applying for an L-1A or L-1B new office application. So for an L-1A new office application, there does need to be proof that the company has secured sufficient physical premises, so an office in the United States. So even though the business doesn't actually have to have been buying and selling already, it does need a physical space. The government wants to see that there is an actual brick and mortar location that can house the employees that are expected to be employed at the business within the first year. So the way to think about the new office application is, in some ways, the government is going to give you a 1 year kind of runway where they're going to say, okay, you can come to the US for a year to get this new business started, but we actually want to see how it's going after a year. So it can be challenging in that respect. You really do need to be ready to arrive in the US and hit the ground running, start becoming active essentially immediately so that you can hit those requirements within that very short 1 year time frame. So to show that you are serious about starting an active business in the US, you do need that physical office space. The employee who's coming to the US on an L-1A new office visa needs to have been, for an L-1A, an executive or manager for 1 continuous year out of the past 3 years before the application is filed. And the employment in the US does need to involve them actually performing as a manager or an executive over the new operation. Third, the applicant must show that the US operation will support an executive or a manager position within 1 year of approval of the petition. Now, this is what I was saying about that very short runway. So within a year of the application being approved, you actually do need to be able to show that the business actually is allowing the manager or executive who's coming on an L1A to actually be performing that role. So if they're a manager, they need to oversee employees. If they're an executive, they actually need to oversee a function or an aspect of the US business. And of course, to do that, the US business does need to be active. So they actually need to have employees. They actually need to have the operations going so that you can show that the company's hit those benchmarks within a year. So how do you do that? So typically in an L1A new office application, a business plan is going to be very important. It's going to show where the company is going to be after that 1 year time frame, the scope of the office, the organizational structure, the financial goals, the size of the investment in the US business, as well as the organizational structure of the foreign entity. So the intimate relationship between the foreign entity and the US entity is going to be key here, not only in terms of the organizational structure, but also that the foreign entity has actually committed capital to the L1A new office in the United States. So for an L1B, so again, this is a specialized knowledge employee. They can also come to the US, start a new office. The application would include proof that the company has, again, secured a physical premises to house the new office. And the application would show that the applicant and the company, the US company, has the financial ability to pay the employee who's coming to the US. So you do need to show again that the foreign entity has committed capital to the US entity to get it operational, and that would include paying that specialized knowledge employee. So let's talk about these key definitions. Again, for an L1A, this is to support a manager or an executive who's coming to the US to work for a branch or a subsidiary or an affiliated entity of a foreign business. So what does executive capacity and managerial capacity actually mean? We have the definition here on your screen. So executive capacity means that the person is assigned within the business to do the following: to direct the management of the organization or a major component or function of the organization, to establish the goals and policies of the organization or the business, or that component or function. The person exercises wide latitude in discretionary decision making. So they are the ultimate decision maker on certain key aspects or functions of the business. And they receive only general supervision and direction from higher level executives, the board of directors, or stockholders. So again, they really are in many ways the ultimate decision maker on at least a key aspect of the business. They don't need to be the CEO overseeing the entire company, but they do need to oversee some key aspect of the business. Now, that is for executive roles. For managerial roles, the applicant needs to be assigned within the business to manage the organization or a department, subdivision, function, or component of the organization, to supervise and control the work of other employees who are supervisory, professional, or managerial, or to manage an essential function within the organization. The person should have the authority to hire or fire or to recommend the hiring or firing of personnel. They would also be engaged in promoting personnel, and they would have discretion over the day-to-day operations of the activity or function for which the employee has authority. So a first-line supervisor is not considered to be acting in a managerial capacity merely by virtue of the supervisor's duties, unless the employees supervised are professional. So this role, you really are managing higher level employees who may themselves be managing employees. So this really is for a key role at the company, whether an executive or a manager. And this also sheds light again on that L1 new office requirement, which again, you need to show within a year that the US branch or entity is actually able to satisfy these requirements. So within a year, if they're here on an L1 as a manager, that they are going to be within a year overseeing employees who are themselves managing people or who themselves are professionals, skilled employees. So do keep that in mind when considering an L1A new office application. So how about the L1B? Again, this is for individuals who have specialized knowledge. So what does that mean? That means that they have knowledge that is characteristic of someone who works for the business in developing a certain product, service, research in certain equipment or techniques. And this is really a more advanced level of knowledge or expertise. It is not common in the industry. It is specialized. So again, it would not be commonly held throughout the industry. So to determine this, what does the government look at? They would look at where this individual falls within the organization, which is actually also true of the L1A. They would want to see that the manager or executive, where they are in the business structure. They would want to see how the individual with specialized knowledge works in terms of what the organization manufactures, what they develop, whether it's the products, the services, the machinery that's used, whether it's research being done by the organization. And determinations concerning advanced knowledge do require review of the person who would be receiving the visa, their knowledge of the specific petitioning organization's processes and procedures. So they do need to show that they have knowledge of what the business does, specialized knowledge of that specific business. So those are the two main categories, the L1A, the L1B. With that, I am going to pass it off to Kelly to talk about the kind of the more practical aspects of an L1, including what documents need to be submitted with an L1 application.
Thank you, Dustin. Perfect. So let's talk a little bit about just the actual document requirements for an L1 petition. So one is a form that you need to submit with U.S. Citizenship and Immigration Services. This is called Form I-129. There is also an option to submit a supplementary form called an I-907 to ask for premium processing, meaning you pay an additional fee and the government will issue some type of decision, an approval, a denial, a request for evidence within 15 business days. And then if it's a request for evidence, you would submit a response and then they'll submit a final decision usually within those 15 days, although they do have discretion to issue second RFEs. The other things you're going to submit are the supporting documents that show you meet each of the requirements that Dustin has outlined previously. So you need corporate documentation showing this qualifying relationship between companies. So if it's a parent subsidiary, you're going to show that one parent owns, the subsidiary. If they're affiliates, you're going to show that common ownership. So any of the documentation that proves you meet one of these affiliate branch subsidiary parent relationships. The other is the proof that each company is doing business, or if it's a new office, proof that the company abroad has been doing business and that they are opening a new office in the United States. So these are typically going to be things like tax returns, audited financial statements, commercial lease agreements, invoices showing active trading, payroll summaries, anything that demonstrates that the business is operating. If you have a very, very large company, sometimes they don't want to provide these types of documentation, but if the company is that large and it has a huge amount of visibility in major media, often you can kind of submit some of that documentation because there will be publicly available information. In many outlets. So you can provide that in lieu of some of these sensitive financial documents that companies may not want to provide. You also have to provide proof that the employee worked for the company abroad for one continuous year out of the past 3 years in a managerial, executive, or specialized knowledge role. So as a baseline, pay stubs are very easy way to show that somebody's been actually employed for a company for a specific year. And then you want to prove that they meet, these requirements. As Dustin outlined, there's very specific definitions for who is an executive, who's a manager, who holds a specialized knowledge role. So you really need to provide a lot of detail, a detailed job description, a chart that shows the percentage of time spent on various duties. You want an organizational chart that shows the hierarchy of the employee within the company, particularly if you're trying to show they're a manager, they're an executive, that they're very high up, in senior management. If you're for specialized knowledge, work product can also be very helpful. To show that the projects the person is working on are, really of that caliber that would qualify them as a specialized knowledge individual. Usually helpful to provide some type of, cover sheet kind of explaining what the evidence is showing. Um, and it's something to keep in mind that, again, you have to prove this for the role they held for one continuous year. So if somebody held multiple roles within a company and they never really had, one continuous job, maybe they were, head of sales and then became VP of sales. So you really do have to think about how can you craft this job description to explain that they meet this executive, they were an executive or they were a manager for that full year. So you do have to kind of keep that in mind when there's somebody who's been promoted or their job has changed. Additionally, I think sometimes there's a perception that the person must be coming to the US to hold the exact same job that they held abroad, and that's not the case. You can be coming to the US to hold a completely different job, as long as you can demonstrate that you're qualified for that job. So obviously, from the perspective of proving that you meet the requirements, perhaps it's much easier if you're a VP in, VP of sales abroad, and now you're coming to hold a VP of sales role. You're going to be describing kind of the same things. Very often, however, people are coming to the United States or being transferred maybe for a promotion, maybe for to start up a new office for a different type of job. And so you do have to think about how can each of those, job descriptions be crafted to show that you meet one of the, criteria. So somebody who might have been a manager abroad, maybe promoted to be an executive in the United States, or somebody who's a specialized knowledge worker abroad, maybe being promoted to be a manager in the US, to run a new team. So you do need to be thinking about that and also knowing that you do not have to be holding the same exact job, but you do need to demonstrate, especially if it's not the same job, how the person's education, skills, and experience qualify them for this job in the United States. All right, let's move to the next slide. So let's talk about requests for evidence. So requests for evidence are unfortunately very common for L1 petitions. I looked up some of the more recent data this morning. So, RFE rates were over 50% in 2019 through 2021. It's been a little better. 2022 through 2024, rates have been more in the 30s. So that has been, a positive, change in terms of how many RFEs are being issued. That being said, there still are many RFEs issued for, L petitions. We anticipate perhaps, more will be coming, in the coming years as well. And most of these RFEs are challenging whether or not the applicant meets this definition of manager, executive, or specialized knowledge worker. Um, there are some very kind of objective elements to the L1, if there's a qualifying corporate relationship, things like that. But for whether or not somebody qualifies under these regulatory definitions, oftentimes the amount of documentation that they want to see to support these arguments is quite substantial. So they do want, like a one-page letter that says, yeah, they're going to manage a team and oversee objectives. That's not going to be sufficient. They really want to understand how does this company work and what do you do for this company? If it's not a really, really obvious case where it's, somebody at the C level, with, hundreds of people under them, you do often have to do more to really demonstrate, what mechanisms you have in place for, if somebody's in the United States and they have one employee, how are they really fulfilling an executive role? You do have to be able to demonstrate sometimes, if there's a really robust operation abroad and it's supporting the US company while they get up and running, you can bring in that to show, well, yes, it may look like there's only one person here, but actually we've got a team of 50 in the UK that are dedicated to helping open this US office. So sometimes you do have to be creative, especially because you do get these RFEs and they do want, they're always very quick to say, like, the letters are important, but what they want is objective evidence that can back up what you're saying. So that's where things like work product can be really key. Um, if an executive has been the person who, like, signed off on the main policy handbook that's being used, or if the specialized knowledge worker like was, one of the key initial employees designing a system that now is in place and regulates, what 800 different employees do. So sometimes you really do have to spend time with the employer, with the employee, and really dig into what the person is doing and get a more technical understanding so that you can communicate that to the government and really convince them that they do meet, one of these criteria. All right, let's talk a little bit about timing and also dependence. So for the L1, the way that it works for the vast majority of applicants is first you have to submit an application to U.S. Citizenship and Immigration Services. This is that I-129 form, plus all that supplementary documentation we talked about. Processing times, regular processing times are several months. You can pay this additional fee for premium processing to get that answer within 15 days. Used to be 15 calendar days, now it's 15 business days. Um, and as I mentioned, it can be an approval denial, request for evidence, a notice of intent to deny. If it's a request for evidence, usually you have about 87 days. That's the longest period they can give you, and you submit your response. A notice of intent to deny, you have 30 days to respond. After the L1 petition is approved by USCIS, so then the employee applicant can, if they're outside the US, they can go ahead and schedule an appointment at a US consulate where they live to get the L1 visa stamp in their passport. If they're already in the US, let's say they came as a B1 business visitor and they were doing some initial setup activities and they changed their status to L1. So that's another option. And so if they change their status and they get a new I-94 for L1, they can just start working right away. And then when they travel internationally, they could take that approval notice and go get the L1 visa stamp. Um, Spouses and unmarried children under 21 can accompany on the L2 dependent visas. The spouse can work, the children can attend school, and a big benefit for the spouse, they used to have to actually submit a work authorization application. Now, as things stand, they can qualify just on the basis of entering as an L2 spouse. When you enter, you do have to check your status document, which is called an I-94. This can be accessed online. It should say L2S. Unfortunately, I-94 errors are very common. So if you see that the S has not been added, you do want to contact Customs and Border Protection, their Deferred Inspection Office, and ask them to make that change. One thing I also want to mention is just that for Canadian applicants, there is an ability to go to the border and have Customs and Border Protection adjudicate your initial L1 application. This can be very favorable for, Canadian citizens because they can kind of just take all the paperwork to the border. They can kind of have this interview. The package is ultimately sent to USCIS and then an approval notice is generated. But this can be a good option, for Canadian citizens. All right, a very common question. Does an L1 lead to a green card? I think for every temporary visa, there is this question. And so there are green card options that are available to people who are on L1. So if a green card option is available to you while you're in the US on an L1, yes, you can go ahead and file for a green card. We've listed here kind of two of the most common ways that people on L1 pursue a green card. So one is the EB1C. This is a multinational manager or executive green card. It has very similar requirements to the L1A, but there's a heightened standard. So somebody maybe who's like doing, coming in and maybe the L1 company in the US is very small. Maybe there's two employees, but they're going to grow the operations. Probably better to grow the operations a bit more before you go ahead and apply for that EB1C. Additionally, there's some extra requirements for the EB1C. The US business has to have been operating for at least 1 year and doing business. So there is that, it doesn't have that new office option that the L has. Other than that, the requirements are very similar. Have to have that qualifying relationship between the company abroad and the US company. Both companies have to be doing business. Employees have to work in an executive or managerial role for at least 1 year in the past 3 years. If you've been in the US, let's say sometimes people will come on an L, they've been here for more than 3 years, they can still apply for the EB1C. They're not foreclosed from that. Ultimately, what they'll do is they'll just adjust the time if somebody's in the US when they're applying for the EB1C. So they'll look back at the 3 years prior to entering the United States. One thing that's important to know is let's say you were a specialized knowledge worker abroad and now you're here as a manager. Unfortunately, the EB1C is not going to be available for you. You have to have been an executive or a manager abroad and then have been transferred to the US to be an executive or a manager. And they will look back. We've had clients where maybe they've been on an E2 for several years and now they finally are interested in the EB1C. And there's all this also, I think sometimes this misconception you cannot go from an E2 to an EB1C. That's not true. If you meet all the other requirements, if your role is managerial or executive, you can certainly still go to the EB1C from an E2. Um, so, when that's the case, though, they are going to look back at what your job was, even if it was many, many years ago. They're going to want to know, what were the organizational charts looking like at the time that you were a manager? What were you doing? So, for many people, if they've already applied for the L1, they may have that documentation handy. But it is something to keep in mind if the EB1C is ultimately your goal, that when you are transferred, you will have to kind of justify that role as managerial or executive in the future when you apply for the EB1C. The benefit of the EB1C is you can go right ahead and file, the I-140 immigrant petition. Very often the EB1 category is current, which means there's green cards available. So people can kind of apply for and get their green cards faster. You don't have to go through the labor certification process, which is a big benefit. However, for many people on L1B or maybe people that are on L1A now, but they were, don't qualify for EB1C for some reason, they can go through something called the PERM process. So this is where the company will have to test the U.S. labor market to determine if there's any willing, qualified, and available U.S. workers who meet, the job's minimum requirements. If they do this labor market test, they place advertisements. It's a 2-month period where they place those advertisements, and they don't find anybody, they can go ahead and file a labor certification. Labor certifications are taking about 13 to 15 months. If that gets approved, then they can file the I-140 petition, and then they can move on to the green card process. So if you're doing the labor certification process, there's kind of almost a 1.5 to 2 year period where the company is working on things that you can kind of skip if you go straight to the EB1C. So there's definitely many benefits to the EB1C. If that is an option. But if it's not for some reason, the perm process is also very viable for people on on the L. You do want to think about it again, like early though, because the L1B, you're going to run out of time after 5 years. The L1A, you're going to run out of time after 7 years. And right now, the perm process end to end is taking, 2, 3, sometimes even 4 years till you actually have that green card in your hand. So you do want to be thinking about this and kind of planning ahead for that.
Perfect. Thank you so much, Kelly. And with that, we actually have not received any questions. So feel free to use these last few seconds to send in a question if you have it. And in the meantime, I do want to thank Kelly for sharing your expertise. Thank you all in our audience for being with us today. Do keep an eye out for the email, which we will send. If you'd like to discuss the circumstances of your specific case, do schedule a consultation. We make that really easy on our website to schedule either a 30-minute or an hour-long consultation. We'd be happy to talk with you. And if you're not quite ready for a consultation, do check out our YouTube channel as well as our website where we have a very extensive blog. All right, we do have a question. My wife works as a manager with one of the biggest banks, but no one reports to her. Might she qualify for an L1A? Kelly, I'm curious to get your thoughts on that.
Yeah, of course. So it's possible, right? I think that there is something called a function manager. And so this is somebody that does not manage personnel, but they manage a major function of a company. It's a kind of a tricky argument, but we have used successfully. Really what's tricky about it is you have to show that the person is managing a function that is essential to the company, that they have a senior authority over this function, that they manage the function and don't actually perform it. So what that means is even though a function manager generally will not have direct personnel reports, they do need to have indirect reports who are kind of doing the operational work that they're overseeing. So it is potentially possible, but is, a more complex argument to have to make.
Great. And this next question is one I really like. Can someone who's an entrepreneur abroad, they have a business abroad, and they want to come to the US to open a branch in the US, is that possible for someone who is a solo at the foreign company?
Yeah, so an owner of a company abroad can come to the US and start a new office. There does need to be a US like entity, like an actual entity, like an LLC, a corporation. Um, so yes, like it is possible, but it doesn't work if they are a complete solo because there does have to be this company abroad that's continuing to operate. So if you are someone you're the entrepreneur, you started your company abroad, maybe you have a few people working for you and you're going to come to the US and open this new office, and the people abroad are going to keep working and running that company, then yes, that can potentially work. But if you are just wanting to come over yourself and the company abroad is not going to operate anymore, that would definitely be problematic. And I think you really wouldn't have much success convincing USCIS that you were an executive or a manager if you were a solo, in your home country. So, entrepreneurs, the L1 can be great for them, but I think it is tricky. And if you're somebody who is wanting to just move your entire operation to the US, that's something that's really more appropriate for an E2. So good to look if you have any treaty country nationality you could use for that.
Perfect. Great questions. Oh, we have a couple more. I'm working as a senior database administrator level 3 for more than 5 years. Do I qualify? So this is a great example where a consultation would be helpful to actually talk through what is it you do in this role. We can get into the details and whether the L1A is a good option. So please do schedule a consultation if you want to discuss the specific circumstances of your employment. How hard is it to get an extension after 1 year opening a new office with an L1A? And in general, is it easier to get an E2 or an L1A? Those are great questions, and I will assume in the response that you have E2 nationality, so you have a passport from an E2 treaty country. For those of you who do not have E2 treaty country nationality, uh, you may obviously be leaning toward an L1A. But Kelly, I'm curious what you think about those.
Yeah, so I think how hard is it to get an extension? As Dustin, I think you mentioned earlier in this presentation, 1 year is such a short timeline to get the business to the point of, being really successful. So I think that often it is a real challenge for people to get that, extension after 1 year. You have to go in with a really solid hiring plan and a really solid plan for either capitalizing the company through investment or some type of cash flow or the revenue. So I think at the end of 1 year, what they really are concerned about is one is, is the company operating? Is it doing well financially? If its revenues haven't picked up that much, but it's still supported by a successful parent company, that's likely fine, but they do look a lot at hiring because at the end of 1 year, the company has to be able to argue that it is large enough to support that managerial or executive role or specialized knowledge role. And so I think oftentimes our clients, what they find that what they struggle with a lot is that it's a 1 year runway where we recommend hiring at least 5 people. And that's not a magic number. It could be a little bit less, it could be a little bit more, ideally more. But really, again, what you have to be thinking about is, are there enough people who've been hired that they can arguably be said to be doing all the operational, administrative, daily work that they don't want? Like, does this office really support an executive? Does it really support a manager? And so, yes, I think there is often a lot of scrutiny on those extensions after 1 year. There's also a lot more scrutiny on an L1 new office. Those are ones that receive RFEs at a much higher rate. Um, is it easier to get an E2 or easier to get an L1? This does depend on your facts. That being said, I think generally if my clients have an option for an E2 or an L1, almost always I will recommend the E2. For many clients, that means they can get a multi-year like if it's again, because for an L1 new office, you're only going to get 1 year. If somebody wants to start up a brand new operation on an E2, if they're Canadian, if they're from the UK, many, many places, they can get 5 years. Even places where they can't get 5 years, sometimes they can get 4 years, they can get 2 years. So you're getting more time. And additionally, for the E2, you're only focused on this one business. For the L1, you really have to deal with two businesses. How are two businesses doing? How does my role fit into two businesses? So I think that it's fact specific. Like there absolutely may be circumstances where an L is better than an E for one reason or another. But on the whole, I think the E2 often is easier to get than an L1, particularly if you do have a successful parent company that's capitalizing the E2 and you're sending someone over as an E2 employee. That is going to be a lot easier than it is to do the L, where you're proving, how both companies are doing, you're proving the job on both ends. The E2 is just going to focus on that US company.
Great. And also in L, you're going to USCIS and then the consulate, whereas the E2 is nice because you only are dealing with either USCIS or the consulate, which is also nice. Perfect. Well, Kelly, thank you so much again. And to our audience, great questions. We do hope to see you on future webinars. And in the meantime, stay well and stay safe. We hope to see you soon.
Thank you.